Hi everyone, this is David Slonim of the Slonim Law Firm. Today we're going to be talking about guardianship and special needs trusts, what every parent needs to know. It's going to be about a 40-minute presentation covering both guardianships and also what kinds of special needs trusts are out there and how they can benefit you and your loved ones. So why don't we get started? So today we're going to talk about a guardianship in general, and then specifically certain kinds of guardianships that are going to be appropriate for uh, families with developmental needs in particular. So, in general, a guardianship is someone who's appointed by a court to oversee a person's legal, financial, and medical affairs. A guardian is not somebody that just becomes a guardian just because they want to. In order for a person to be legally a person's guardian, they have to go to court to do that. And usually, that is something that's required for a person that is incapable of managing themselves, either through incapacity or age, being a minor. So, when we deal with a guardianship, we have a certain set of actors that are involved in the guardianship. When we file with the courts, then there's going to be the proposed guardian and also the person that's filing the documents with the court. That's specifically going to be the petitioner. That's the person requesting the guardianship overall. The ward is the alleged incapacitated person, or AIP for short, and that's a person that the guardianship proceeding is centered around. The proposed guardian is who the petitioner wants to be the guardian. Usually that is one and the same, however, it could be different people depending on the nature of the proceedings and the requirements for this particular guardianship. Finally, there's also going to be somebody that is appointed to represent the ward. That somebody is always going to be an attorney, but the court is usually going to be the one to appoint that person, usually from a list that the court has. They usually have a guardianship experience and are there to represent the needs of the ward. So, again, with a guardianship, it's going to be required when the person is going to be over the age of 18. Then that person, if we're dealing with a developmental disability situation, then once that person becomes the age of majority, the age of 18, then you can't have access to their medical records, make legal, financial, and medical decisions unless you have specific authority from them or have court authority through a guardianship. A guardianship is different from a durable power of attorney in that a durable power of attorney is going to be permitted and drafted by the person making that document. If a person doesn't have capacity because of a developmental disability, then that's going to be impossible for a power of attorney to get created. So that's where guardianship is going to come in. If there isn't a guardianship, we usually see this when a person either is just going to be turning the age of 18 or sometimes even after, and the parents realize, well, I can't now talk to my child's doctor. Then there's also the possibility that there's going to be the exploitation, abuse, or neglect of that individual, and that's where guardianship is going to be necessary. Guardianship is not something that you can just get on your own. It has to go through the court system. So only a judge can actually appoint the proposed guardian, maybe you, as your child's guardian, and then that is going to be ordered by the judge there. So let's go over one type of guardianship called a guardianship advocate. And this is kind of set forth by certain Florida statutes. And here the courts are encouraged to consider appointing a guardian advocate when appropriate as a less restrictive form of guardianship. So again, guardianship is really kind of tightly controlled by the courts because it is so powerful. It does require certain rights to be removed, and in so being, then the judge is very careful as to what rights are going to be removed in that way. So it is one of the lesser restrictive forms of guardianship, but it is still a guardianship. One interesting thing about a guardian advocate is that this is theoretically something that you, as the proposed guardian and petitioner, can possibly do on your own without an attorney to represent the proposed guardian. This is one of the few areas of guardianship that does not require an attorney to proceed, although I strongly recommend that an attorney is going to be involved, because there's a lot of things that you may just not be aware of that are necessary in order for the guardianship to proceed properly. And there may be some things that you can even have waived that you may not be aware of unless you have an attorney involved in that way. If there's a reason for the guardian advocacy to be inappropriate for this particular situation, then there's other types of guardianships that are going to be potential. And that's going to be an emergency temporary guardian. So if there's any immediate danger of abuse, exploitation, or neglect. If there's a plenary guardianship required of the person and property, this usually comes in when the person that is the alleged incapacitated person does not have a developmental disability, but some other disability that's occurred through some other reason for incapacity, such as age, dementia, traumatic brain injury, and the such. Many of the guardianships allow for what's called a standby guardian, and that standby guardian is going to be in place to be kind of pre-approved, so to speak, in the event that the guardian themselves cannot act on the ward's behalf at that point. So let's talk about guardian advocate kind of more in detail. Again, I talked about a developmental disability. And the court is going to appoint a guardian advocate without an adjudication of incapacity. So typically, when we go and file for a guardianship, then the judge is going to have a separate order. It's actually a separate case as well, determining a person's capacity or incapacity. The guardian advocate situation, there is no adjudication of incapacity. So there's no order that says the person is incapacitated. The developmental disabilities are going to be kind of the reason for that, and that is going to then have to be shown in very specific ways. So, a person with a developmental disability or intellectual disability has certain specific criteria: cerebral palsy, autism, spina bifida, Down syndrome, and such, that manifested before the age of 18. And has to constitute a substantial handicap for the rest of the person's life, and substantially impairs a person's ability to appropriately perform activities of daily living. This is usually shown by a doctor's letter or an IEP if you've got that. When we're talking about what's going to happen in a guardianship, and a person's rights are going to then get affected through the guardianship, this is going to be specific to a certain number of rights that have been set forth in the statute. And again, these rights are going to be specific in that the ability for us to define which of these are going to be removed are kind of defined ahead of time based on kind of the individual, and courts prefer us to have a narrow focus on these as much as possible here. So while these are all the potential rights that could be removed from an individual, it doesn't have to be all of them. We can narrowly focus them if possible. So the rights are going to be the right to vote, potentially, the right to personally or just in general to apply for government benefits, to have a driver's license, to travel, to seek and retain employment, to contract, to marry, and if the right to enter into the contract has been removed, then that right to marry is subject to court approval. To sue, defend lawsuits, to manage property, or to make any gift or disposition of property, to determine the ward's residence, to consent to medical and mental health treatment, and to make decisions about the ward's social environment or other social aspects of his or her life. So these are all things that could be removed, doesn't mean all of them have to be. And so we can have a determination ahead of time by discussing amongst ourselves and maybe even with the LSOR what is going to be the most narrowly focused version of the guardianship that's going to be appropriate. And even if these rights are removed, the kind of interesting thing is that this does not require them to always be removed. They can actually be reinstated if the individual shows the capacity to be able to do that. Then we would request the court to then start a process called a suggestion of capacity to allow for that to be reinstated and kind of reviewed before that reinstatement. So when this is all done, that's kind of in place for the life of the guardianship. Sometimes that guardianship may be beyond your own lifetime. And so then when that happens, then we are going to have what's called a standby guardian that could be in place. And that standby guardian is going to be potentially available, but it's not automatic. So when we have a standby guardian, then you are going to have a petition by the current guardian to say, if something were to happen to the current guardian, then this is the person that is suggested to be the next person that's going to be around. And they're empowered to assume the duties of the guardianship immediately upon the death, removal, or resignation of the guardian uh, of that situation there. So when you are going to apply to become guardian, there's certain requirements that are going to be important for you to be aware of. First off, you've got to be over 18 to be a guardian. So sometimes a sibling that is a minor still cannot yet be a guardian, but they could potentially be involved later on if you want to petition as a standby guardian to have them involved. But right now, they have to be over the age of 18 and be a Florida resident, unless that non-resident is related to the ward through blood or marriage, or legally adopted child or adoptive parent. A person is not able to serve as guardian if they're ever convicted of a felony. So if there's a felony that was even 20, 30 years ago, then that's not going to serve. And so, if there's ever any other impairment making you incapable of your guardian duties, then that's going to be a problem. A creditor cannot be a guardian of an individual or serve in a healthcare or business capacity of that individual. You can't be making money off of the ward, in other words. A person has to apply to the court to become a guardian, and that's again required application to the courts. And there is an actual application that you file when you're going through that process. When you are also getting appointed, then there's a opportunity for the judge to require a background check, a credit investigation, and at least an 8-hour educational course. This is something that can be potentially waived. However, that's where having an attorney represent you is going to be helpful in that respect. So you're going to initiate a guardianship, usually in a guardian advocate situation when the ward is around 17, somewhere between 17 and 18, or anytime after 18 if the guardian feels that the ward meets the requirements. And again, those requirements are going to be mostly a developmental disability situation. We can also have the standby guardian initiated also at the same time that you're getting the guardianship set up initially there. And then if we needed to have an emergency or plenary guardianship set up, then that's going to be put into place when there's an immediate danger to a person's health or other assets. And if the time of incapacity and there's no advance directives in place, again, that's where we're going to be looking at an emergency temporary guardianship or a full blown plenary guardianship. So, guardianship is not, of course, something that is ever taken lightly, and that also is going to be important when we look at the costs, literal financial costs of a guardianship. So, every court jurisdiction is a bit different as far as what the filing costs are, but I'm going to cover what's in Brevard County at least, and these numbers are always subject to change depending on when you're looking at this video. So the filing costs for a guardianship are going to be about $400. And then if we have to petition to determine incapacity, then that's another $231. And then if there's an examining committee that is required, and that's generally going to be for a full-blown guardianship, not a guardian advocate situation, then that is something that you're going to generally prepay for. And that examining committee is a committee of 3 individuals that are going to be appointed by the court to have a medical review of the alleged incapacitated person. And that ranges in price. Generally, it's about $1,200 total for the full examining committee. Attorney's fees are going to vary depending on what is going to be the nature of the guardianship. The Elisor, the one that's appointed by the court, usually is going to range in price from about $1,000 to $2,000. If there's a full-blown guardianship again, and the attorney for the petitioner, the one that is bringing the guardianship, varies in price tremendously. There's prices as low as $2,500, as high as $5,000 or more to get you kind of through the door. But again, that is very variable. There are annual costs, so the guardianship goes on for the life of the ward, and so there's annual costs that are generally going to be involved. And if there's financial review that has to get done, then the clerk is going to have a certain range of fees depending on the amount of assets that are reviewed. That's audit fees that the clerk is going to charge. And then for the annual review, then that's going to be something that, of course, an attorney may be involved in. And then those range from 1 or 2 hours generally of time between attorney's fees and paralegal fees. That's approximately $200 to $400. Now, when we're dealing with a guardian advocate situation or any situation where the ward may be indigent, then some of these costs are reduced or removed entirely. But we have to petition the court ahead of time to indicate whether or not the ward is indigent. If a report comes back that approves the indigency status of the ward, then certain costs are removed, basically waived and paid by the state of Florida. So the Elisor costs are generally paid by the state. The court costs are waived. And even if there's an examining committee involved, then the state will pay for those costs as well. So it depends as to kind of the nature and need for that guardianship that will determine your ultimate costs. So even though, as I mentioned before, that there's going to be certain upfront costs, there are annual things that will have to get done. So first, what cannot be waived is an annual plan. This is a forward-looking determination of what is going to be done for the social and medical aspects of the ward. And so this is every year, and it cannot be waived by the court. An annual accounting is kind of a retroactive review of what has been spent of the ward's funds for the for the full guardianship, and this has to provide to the court basically a full review of what has been done by the guardian. And so this can be waived if there are really no assets of the ward to be dealt with. And I mentioned there's educational course as well. So this is going to cover the guardianship aspect of this discussion, and then we can move forward into the next aspect, which we'll be discussing the supplemental needs trusts if you wanted to move on.